the authority would come from California Code of Civil Procedure, Section 187, and People versus Lujan, 211 Cal. 4th, 1499. And let me ask, Mr. Lewin, my question is, why do you specify age 60? The CDC guidelines regarding COVID-19 specify age 65 or older, and that's the scenario we're dealing with. Why do you say 60?
You know, I believe at the time when I wrote it, Your Honor, as the court remembers, what happened is this motion was filed originally under seal, the first version. Oh, okay, I'm sorry. Can you hear me now? Is that better?
Much better.
Okay. So, originally filed it was filed under seal because we didn't want to panic, you know, jurors and other witnesses, etc. And at that time, Your Honor, they were saying that witnesses over 60, individuals over 60 had a much greater health risk than those below 60. That's why we chose 60. Just so it's clear, I don't think, in terms of our out-of-state witnesses, I think almost everybody is over 65. There might be a few that are between 60 and 65, but I still think, Your Honor, that given the situation with having to travel through 2 international airports, everybody is coming from New York, New Jersey, etc., Boston. I don't have the list in front of me, but in essence, people are having to travel through very large airports, at least 2, that the rationale would still apply. That the bigger issue would go towards primary versus non-primary, and it's the people's position that given the orders by the Chief Justice, that the court would be able to say, and I'll give an example, Your Honor, Douglas Durst would likely be, the defense would probably call him a primary witness. We would probably say, you know, in terms of what Mr. Durst actually on trial for, he's not primary, but you could certainly make the argument that he is substantially more primary than, say, Kathie's classmates. However, when you start balancing the idea of what is the risk-benefit of the witnesses testifying remotely versus having to fly out here, and again, to go back to something Mr. Chesnoff said, is one of the advantages of the witnesses testifying remotely by camera is they will have their masks off. People will be able to see their whole face if they're testifying remotely. The jury can see their expressions.
We may well do something like that because we have the sneeze guard, we do have the shield up, but we may be able to do something with witnesses at least revealing.
But that is the reason that we had said 60, and we do believe, Your Honor, that for the purposes of this motion, when you're looking at the protection of the public, we do think that 60 is a good balance. But I can't tell the court right now that there's a witness I can think of where the 60 versus 65 would make a difference.
Very well. So the questions I have are, first of all, does this procedure satisfy Maryland versus Craig's protection, the Sixth Amendment right to confront and cross-examine witnesses? Second, is there good cause to create a non-statutory procedure? And third, will you specify the witnesses and their circumstances? You've described only Dr. Helen Block, and I did have her circumstances as of March. I do not have current circumstances about Dr. Block. So if you would answer those questions within your argument, I'd appreciate it.
Okay, so we believe that absolutely, Your Honor, when you're looking at the constitutional protections, the Chief Justice, I think we have to presume that the Chief Justice of the California Supreme Court is well aware of what is constitutional and what is not constitutional. The orders that they have made, which have repeatedly emphasized the idea of using alternative means of having witnesses testify remotely, those are in several of the orders, give the court instruction and direction as to what the priorities are. Does the court wish any, and again, if you wanted to look at the issue of the constitutionality, if they have found a compelling societal interest in allowing a juvenile sex victim to testify remotely, I cannot see how you would not have at least as legitimate of a public safety issue with respect to the COVID situation, these witnesses as you would there. So I think that although COVID was not contemplated when they made this exception, it certainly fits within it. So that would be the first issue. The second issue, in terms of the specific witnesses that we are going to be calling, we made it very clear, Your Honor, that it only applies to witnesses who are out of state, that have to fly in. And that basically is going to be, I don't have the full list of witnesses, but in the end, Your Honor, their situations are going to be, in essence, the same with a few...
Just, there's a kind of an underlying assumption you're making that I would make a rule for the trial as if it were a rule of court or a statute, that you would simply invoke this ruling when calling a witness. But when you look at Lujan, that was one witness, and the circumstances of that one witness were examined before the court agreed that a special procedure ought to be utilized. I believe that I must answer the question as to each witness rather than create a general rule.
Your Honor, may I ask the court this?
But Your Honor, this is Mr. Chesnoff. One other thing is, one of the big reasons for Lujan was the state's interest in protecting the child, along with the inquiry.
Yes, of course. Protecting the child is important, and protecting human life of all participants is important, and that's what we're trying to accomplish here. This is an unusual circumstance. The legislature did not exactly foresee it, and that's why long ago the state established a Code of Civil Procedure Section 187 so that a court might fashion rules to accomplish all of these objectives. It's in the interest of justice, and so I think that's a fair framework. So you may continue, Mr.
Thank you, Your Honor. So what I would suggest then, Your Honor, is when I leave court today, I will contact all of the witnesses that are out of state and over 60 years of age. With the court's permission, and I don't think I have any out-of-state witnesses now who are less than 60, but even if we do, I would think that it would be in the court's interest that I contact those witnesses. I say, listen, we're going to be starting up no earlier than July 27th. I need to explain to the court, are you willing to fly out here to testify? If you are not willing to fly out here to testify, and you believe that there are issues relating to your health where you need to testify remotely, I need you to please explain those reasons in a response which I will furnish to the court. I will do that with each and every witness that's left. I'm not in the position to do that today because I did not know, and I've actually held off, Your Honor. I send these updates to the witnesses, but I've tried not to contact them when I don't have anything to tell them. So that would be my plan, but I'm pretty confident, and I guess I'd ask the court, Your Honor, is if what we get back, is the court willing to utilize this option for a witness who simply says, listen, I'm over 60, I don't have any pre-existing health issues, but I'm concerned about flying out here, cross-country, being in the airport, 2 different times, etc. And obviously, these people are going to have issues with children they have and elderly relatives they have. In other words, how detailed do you want them to get? And I ask that simply because I think the court is well within its discretion to be able to say, listen, no one's disputing what the situation is with individuals getting on airplanes and flying out here and the risks that they take. And I am finding that since there's no minimization and no restriction of his confrontation rights, that I'm going to authorize this procedure. So I'll do whatever the court wants me to. I guess I'm looking for guidance. How would you like me to handle it?
Well, first I have to hear the defense argument. Hold on. The way this works is I asked Mr. Lewin to support his motion, and now Mr. Lewin has asked me a question, and it's premature. I obviously have to hear the argument of the defense as to whether or not this does satisfy Maryland versus Craig, if there is good cause to create this procedure given the pandemic. And there's a further question, and I've said this all along, I need to see the technology itself. I need to see for myself that indeed a lawyer, a juror can see the witness, hear the witness, and Mr. Bellion assures us that there's no sacrifice of confrontation. I want to see that demonstrated to me, and then the second part of your question is as to the showing required for a particular witness, and of course I believe I would need to hear objections from the defense as to a particular witness, whether or not that witness ought to be testifying remotely and for what reasons. I do think the CDC guidelines of persons 65 or older or with underlying conditions or both, I believe that I would find good cause in that instance, but again, they have specified 65, though you've chosen the number 60. So that's so before the defense argues, I want to hear the rest of your presentation, Mr. Lewin.
Yes, Your Honor. And with respect to and the court, Your Honor, my understanding is, and I think this is done on the record, the court had actually granted this motion previously.
The only caveat was I wanted to see the technology. Copy and paste, please.
I'm sorry, Your Honor, I didn't hear the court.
Copy and paste.
Okay, will do, Your Honor. So going forward then, we are prepared to give the court a demonstration when the court wants to have that done. So if the court, and that would involve Mr. Milius demonstrating to the court. We've done a lot of work on this. Zoom, when it's double passworded, is very secure. There are numerous things that have been done to make sure that this process remains confidential, but I don't think the court's not asking for the demonstration right now, correct, Your Honor? The court is asking for this demonstration.
Subject to passing the test.
Your Honor, I would imagine that the court would prefer the demonstration in the actual courtroom that we're going to be using.
In Inglewood, yes.
So which kind of sets up, Your Honor, and just so the defense is ready for this, one of the problems that we're going to have is that I've got to arrange, transportation, etc., the logistics involved in getting witnesses out here. If we start July 27th, it's not as if I can say, okay, our witnesses are ready to go, because we've got a lot of out-of-state witnesses starting July 28th. So my plan would be, subject to the court approving it, would be to do as I indicated. If the court preliminarily grants the motion today, I will contact each and every witness to find out what their position is in coming. I can tell the court, and I've already told counsel, just about every witness who's been out of state, this is no surprise, Your Honor, they're very apprehensive about coming here because of the issues that are involved. And I should also say, which I think demonstrates the sincerity of our position, is there are two witnesses who testified by conditional examination who live in Los Angeles, Linda Obst and Ricky Ring. And we have not at this point asked the court to find them unavailable, because in the end it would appear that even though they're both over 65, in balancing, there should be no reason why they can't come in here and testify with respect to social distancing, etc., because it will not involve travel out of state. So with the court's permission, Your Honor, that's all.